Hi, everybody. Good afternoon. My name is Brian Tully. Thank you for joining us once again for our Wednesday webinar. Like always, we'll give it a few minutes for people to log on and we will get started momentarily. Thank you. All right, everybody, welcome back. We're going to get started at this point. So again, my name is Brian Tully. Thank you for joining us once again for our Wednesday webinars. Today's interesting, and it was a little more complicated to prepare because there's a lot of issues I'm trying to fit into this that can actually be simply summarized, which I'll get to. But today is about keeping your family out of court and conflict, kind of one and the same. Going to court is never a conflict-free type of situation. So one of our jobs is to help families stay out of the courts and stay out of conflict. So we're going to talk about the primary ways to do that today. So as I start sharing my screen again, I'm going to ask just to make sure if somebody can let me know in the chat box that you can see my screen and that you can see my video, of course, and that you can hear me. So if you can let me know, that'd be great, and then we can get started. If somebody in the chat box could let me know that you can see me and hear me and see my screen, because I've had those problems in the past. Is that a yes? Is that a no? All right, somebody's saying something. You could see and hear. Great, I appreciate that, Norman. Thank you. In the Q&A box then. I don't know why the chat is always disabled. That's strange because it's not an option that I've clicked. But regardless, I'll try to get it fixed next time before we start up. So here we go. Keeping your family out of court and conflict. So when I hear the word court, it's a stressful thing for me. A short little story. Back when I was at St. John's undergrad, at that point I was focused on becoming a lawyer, and there was a moot court team, and I fought like heck to get onto that moot court team. There was about 20 kids trying out. 5 or 6 made it. I made it to the moot court team. I was probably 21 years of age, 22 years of age. We started preparing for our first event, and I completely hated it. I've never liked courts. I've never liked standing in front of a judge and dealing with those issues and concerns and a jury and so forth. So to me, a court has always been a stressful event. It has always meant conflict because you're there because you couldn't solve your problems otherwise. And as I've matured, of course, and dealt with clients for over 26 years, The reality is that every time somebody's going to court, it's a stressful situation. You don't go to court because you want to, you go to court because you have to. And courts, as we're going to learn, they're not inexpensive and they're not peaceful places. So the reality of going to court is going to be a stressful situation. And there are in our lives many things that can cause stress. And so let's go through this. And yes, court's going to be at the bottom of the list as we move forward. But when we're faced with stress in life, and it causes unfortunate situations. I mean, stress can have a bad effect, of course, on our health, on our aging, on our relationships. So overall, we want to avoid stress. We want to minimize stress. And where we see stress the most is if, God forbid, a family member passes away, a spouse passes away. That's a very stressful event. If there's a health concern or an illness that develops, can be very stressful, of course. Also, if we're facing retirement, whether it's forced or by choice, it's still new territory and it's stressful. Financial obligations, right? Mortgages, credit cards, bills, loans, payments, it can be stressful and it can add up. Fear of the unknown, and I'm here in my early, some would say mid to mid 50s at this point, and there's a lot of unknowns out there as we age. And as I sit with older folks every day, the older we get, the more concerns we have, the more unknowns that are out there. So it's certainly a concern for people. Caregiving is a stressor for families. Whether you're the spouse or the child providing the care, not knowing where to turn, what help to get, what to do, what not to do. Is it time to call 911? There's a lot of stress that goes alongside with caregiving and behaviors and so forth. Being a father of three, children are a stressor. Most of the time they're not, but sometimes they can be. Now, what does this have to do with court? Well, if you look at this and look at the reality of this, several of these stressors can actually lead to different types of stresses in court. So our health concerns, if we don't address and plan for a health decline and are passing away, that can lead to court. If we don't address the potential stress of family, of our children and what's going on in their lives and who our beneficiaries are, if we don't have children, our nieces, our nephews, our siblings, that can cause stress because we can end up back in court if it's not handled properly. And ultimately, our assets, and this is really just a summary of the previous slide, if our assets aren't handled appropriately, the titling of them, where they're owned, what state they're located in, that again can lead to different court situations. Now, you might be saying, all right, what's the big deal? I had to do that once before. What is so bad about court? Well, the reality is that every time, at least in our world, right, you're going to court, there's going to be court fees and there's going to be lawyer fees. That's money. And that can add up very quickly, especially in some of the proceedings that revolve around estate planning and aging. You can have multiple attorneys all billing hourly, and you're responsible for it. So if the proper planning isn't accomplished and in place, multiple attorneys billing hourly is a likelihood if there's a health decline in the future. So why would you ever want to do that voluntarily? In addition, going to court can be a significant time delay, all worse since the pandemic, of course. We look at typical court proceedings, and we'll get in it today a little bit more, but the idea of probate and the idea of guardianship, both of those can take greater than 6 months on Long Island. In New York City, you could be looking at upwards of a year. Okay, so time delays, again, why would we subject ourselves or our families to that unnecessarily? In some of these court proceedings, there's a complete lack of privacy. So papers are filed, for example, in the surrogates court after a person passes away. Everything in that petition for probate or what's called administration is going to have your names, the children, the grandchildren, the beneficiaries that are named. The petition will have them in certain places if they're minors or if they're disabled, as well as what they're inheriting. So all of that in the paperwork is public record. And there are literally companies that go in there and photocopy those petitions. Why would you want all of that personal information out there? I certainly don't. So we want to keep things private for our clients. And ultimately, when you're dealing with a judge and other attorneys, other parties, there's a loss of control. In a guardianship proceeding, for example, again, we'll talk about it a little bit more, but if a loved one loses capacity and another loved one has to step up and say, hey, I need to be guardian for this person, if there's any type of doubt or conflict as to who should be the guardian for your loved one, the judge doesn't have to pick you. The judge can pick an attorney that's on a list. Now you have this non-family member being paid and controlling the personal and legal and financial affairs of your loved one. So there is a loss of control as soon as you step into the courts. And yes, we're going to do another skull and crossbones. Okay, so if it's our health, potentially, and our family concerns, and our assets and how we title them and how we own them that can actually drag us into court, what can keep us out of court? All right. Now, you're not going to be surprised by this answer. You're not going to be surprised by that. But estate planning, what we do and why we're here and why we're talking, can help keep the family entirely out of court for asset reasons, health reasons, and financial reasons. But it's not just any old estate planning. It's not downloading forms from the internet. It's not going to a real estate attorney and getting a 4-page will or a 3-page power of attorney. With all due respect and humbly, it has to be very comprehensive estate planning. The way to ensure your family keeps control, saves time, keeps things private, saves money is through a comprehensive estate plan, all right? And I hope you enjoy the skies opening up and the revelation that is for all of us. Okay, so next point. What exactly are the risks, those health risks and the family risks and the asset risks that comprehensive estate planning can protect us from? We went through a list of risks before and stressors before. So what are the actual risks? I mean, how do I know what I'm trying to put into place so that I can keep my family out of the courts and out of conflict and save the time and the money and so forth? Well, there's certain specific risks that we want to avoid. And every plan and every client that we work with is going to address these issues. But you, of course, as the clients, can certainly decide what to implement and what not to implement. How comprehensive do you want the plan to be? But first and foremost, I've used this word several times already today, the idea of guardianship. So that is a significant risk. And it's not just for aging seniors, because stuff happens, accidents happen, strokes happen to younger folks as well. So the idea of losing capacity mentally, if that were to occur, then the horrible description I gave earlier of multiple attorneys and non-family members being appointed guardian, that can certainly happen. That's a significant risk. Another one is, of course, passing away, but in our context, passing away with assets that are titled incorrectly. What that means is if a person passes away with assets typically that are solely owned in their name alone, then we have to go to court to get the judge to approve, to determine if the will is valid, to appoint an actual executor or administrator, and have the assets passed on to the family, the heirs, or what's called the distributees. Why go through all that? Why put your family through that? So that is certainly a risk. Getting to the idea of leaving inheritances, okay? So remember, we're talking about health, and we're talking about family, and we're talking about assets. Those are the three areas that can bring us to court. So the first two, those are our health risks: incapacity and passing away with assets titled in a certain way. Now, these are the asset risks. Doing these things can put our assets in jeopardy. So leaving an inheritance to a minor beneficiary. You have a 12-year-old. They inherit either directly or because their parent passed away. I'll explain that a little further. Mr. Smith has three children. He leaves everything to his three children equally. Mr. Smith passes away, a third, a third, a third. However, his eldest child passed away before him. Where does that child's one-third inheritance go? Typically, it goes down the bloodline to their children, and they could be minors, or they could be disabled. And if you do not have a comprehensive plan in place with appropriate contingencies built in, you're going to court. And that's not something you want to do. Time, money, stress, why, right? So having that comprehensive plan in place will avoid these risks and these contingencies and protect the inheritance for the minor child without the court getting involved, protect the inheritance for the potentially disabled or even a known disabled family member. You don't want to deal with those concerns. Then you deal with the potential reality that a lot of families see. Do you have a child who's in a rocky relationship? Do you have a child that's actually in a divorce? Well, what happens if you pass away during that proceeding or before the divorce just commences? How is that inheritance in that example with Mr. Smith? What if that eldest child doesn't pass away, but he's on the verge of a divorce, and now the Mr. Smith passes away? That one-third hits that child just as a divorce is starting. What's going to happen to that money? If he puts it into a bank account, if he accepts the inheritance and it becomes a marital asset, you could be losing half of it if it's not handled properly. Now, there are ways to actually create trusts for children so that no matter when the parent passes on and no matter what's going on in that child's life, whether it's a rocky marriage or, God forbid, an addiction, that inheritance can be protected for years or for the balance of their lifetime. The only way you're getting that done is through comprehensive estate planning. Okay? It doesn't happen automatically. The law does not create that for you. The judge isn't going to create that for you. It has to be in your will, your trust, your comprehensive estate plan. Okay? Another significant risk that, while it's significant, gratefully it doesn't happen a lot, but it really does happen. The idea of disinheriting a child. So again, Mr. Smith, we've got three kids. I'm going to pick on the older one again. Let's say the eldest child, the black sheep of the family, moves out west, never talks, doesn't communicate. And Mr. Smith says, I'm not going to leave anything to him. There's no relationship. He hasn't reached out to me. He doesn't care. He doesn't call. Nothing. He gets nothing. So that means we've got all of Mr. Smith's assets passing on to children 2 and 3. Okay. Is there a will? Is there a trust? How are those assets being passed on? If it's through a will, or if there's no will, the sad reality is that we're going to go to the court, and whether it's probate or this administration proceeding, if there is no will, and the law and the judge are actually going to require the other 2 kids to hire a law firm, to hire a private investigator, and go find that child. That child has to sign off on the fact that he's being disinherited. If that child's going through a rough time, which is probably one of the reasons he's not reaching out to dad over the years, why would he ever sign off on not receiving an inheritance? He can fight it. So the idea of going to court when you're treating children differently, terrible mistake. It's a bad idea. And again, people don't usually do it on purpose, but they do it for lack of knowledge. They don't realize that the child that's disinherited, or again, getting even a little smaller percentage, has the ability to stop things, gum up the works, hire their own lawyer, and cause problems. There's your court, there's your conflict, right? Hopefully that never happens to any of you or any of our viewers, but we've seen it. We've seen it. So those are the asset risks that can bring us to court. Now let's talk about the assets. So a lot of folks have real estate, as an example, in different states. So if you're snowbirding, right? New York, Florida, South Carolina, Arizona, we've seen it all. Everywhere you have real estate, when you pass on, a probate proceeding is going to be required if that asset is in your name alone. Why would somebody do that to their family? So again, comprehensive estate planning, an attorney that knows what they're doing, they're going to look at those assets and they're going to say, we need this type of a trust vehicle. Yes, there's fees at this point to set it up, but I can guarantee you it's going to save money later. It's going to save time later. It's going to save us from the courts. It's going to save us from potential conflict later. So there's planning that can be done to avoid the courts and to avoid the conflict, the delays, the money, the costs, etc. And real estate in multiple states is certainly a prime example. We've unfortunately seen that numerous times. We have one client, a physician, and his wife had passed, and there was a condominium down in Florida. I think it took about 2 years for that to go through Florida probate. Unfortunate reality, but it happens. Another unfortunate reality, and this is why we talk about comprehensive estate planning with experienced attorneys that specialize in this, is the use of the wrong estate planning tool can bring the family back into court and cause more conflict. I'll give you a simple example that we've seen. We utilize irrevocable trusts a lot to protect property as people are aging and getting older. And an irrevocable trust, by the way, if you have questions about these things, I can certainly, I'll have time at the end to answer them. But our website, tullyelderlaw.com, tullyelderlaw.com, or tullylawgroup.com, that'll bring you to our website. You go to resources, and in that resources tab, you're going to see all of our past webinars that talk about revocable trusts and probate and powers of attorney and irrevocable trusts and home care and nursing home care. We've been doing webinars for 4 years. So there's a lot of further deeper information on our website if you want to learn more about some of these phrases that I'm using. But this last point that can bring us to court and conflict is using wrong estate planning tools. So where I was going was an irrevocable trust is most of the time, 99% of the time, the right estate planning tool to use when it comes to asset protection and potential Medicaid eligibility down the road. With that said, the use of a life estate is usually not the right tool. And we do get that question a lot. I was just giving a presentation yesterday afternoon up at the Huntington Senior Center, and there's a very specific question about life estates. So I like it when people ask those specific questions because it's a common tool used by attorneys that don't necessarily specialize in this and know what the risks are. And a life estate is a very simple deed transfer. So let's go back to Mr. Smith. Mr. Smith gives his house to his 3 children, yet reserves the right to live there. When he does that, that's called a life estate. He's reserved the right to live there. It is an asset protection tool. It does avoid probate. It does have tax benefits. Those are good things, but it's too simple of a protection strategy. And what I mean by that is there's no contingencies built in there. For example, Mr. Smith can't change his mind on his own. All right, he just can't change his mind anymore because the kids are on the deed. Another one is, what happens if a child becomes disabled? What happens if a child dies before Mr. Smith? There's no contingencies built into that one-page life estate deed. However, if an irrevocable trust is put into place, we've got 30, 40 pages of contingencies and creativity so that Mr. Smith, his wishes will be followed no matter what happens to his children. So everything to my 3, but if this happens, then this, if this happens, then this. That's the comprehensiveness that's needed even for the most simplest of asset situations. You might be sitting out there going, well, all I have is a house. I don't need a comprehensive plan. You do, because that example I just gave about Mr. Smith, with all due respect, is simply just about the house. And if, God forbid, that eldest child dies with that simple life estate situation, first and foremost, that child's spouse and kids are now taking his place. What if that grandchild is a minor? What if that grandchild is disabled? What if that oldest child was Again, dealing with a rocky marriage, a divorce situation. What if that daughter-in-law doesn't get along with the other siblings? All these complications arise because the wrong tool was used. Okay, so we could always talk about that more, but I do hope that makes sense. Those are real risks of getting the family, sucked back into court. All right. So I used that word guardianship a couple times. Let's talk about that a little bit more. A guardianship proceeding is, as I've said, is when somebody loses cognitive abilities. So physically, cognitively, let's focus on cognitively. So cognitively, mentally, they can no longer handle their financial affairs, their legal affairs, their personal affairs. And ideally, there's a power of attorney in place, which I'll talk about next. But a lot of the times, the power of attorney doesn't exist, or it's the wrong power of attorney. And then when capacity declines and that person can't help themselves or protect their own assets or protect their own income, then the family has to step in and start this guardianship proceeding, which is an adversarial court proceeding. And what literally happens is we have to prove to the judge, and which is why we don't do this anymore. It's a heart-wrenching, difficult proceeding. We actually have to pursue to get the judge to declare your loved one incompetent. They're no longer able to make decisions legally. It's not something you want your family to go through. We want to avoid this courtroom, all right? And what happens is you can go to the judge and say, listen, my dad can't handle his affairs personally or his affairs about his assets, which is his property. I used an example earlier about billing and hourly. In a guardianship proceeding, if, again, let's go back to Mr. Smith here, poor guy. Let's say the eldest child realizes dad can no longer handle his affairs. There's no power of attorney in place. He doesn't have the capacity to sign a new one. Happens all the time. And so he goes to a lawyer to start a guardianship proceeding. That is one lawyer right there. Now, what if dad says, I don't want this, just in his condition, if he can put those, connect those thoughts and fight it, the judge can appoint him a lawyer. And then the judge appoints somebody called a court evaluator. We now have 3 lawyers billing hourly. And then what if the middle child says, you older brother, you're the worst one to be dad's guardian. I'm the better person to be dad's guardian. I'm going to get my own lawyer. Now you've got 4 hourly lawyers billing every single month. Don't think it doesn't happen. Unfortunately, it happens a lot. Children fighting, parents contesting it, it happens. Judges just being precautious and appointing different lawyers, it happens. And you can have a guardianship proceeding at $10, $15, $20,000 before you know it. All right? All can be avoided. Don't have to do this. So that's what I was talking about, the costs. Again, you're looking at 6, 8, 10 months worth of time. So a guardianship court, the Supreme Court in Mineola or over in Central Islip, it's not where you want your family to be. The other courthouse that we see a lot is the surrogates court. And this is actually the surrogates court over in Nassau County on Old Country Road. And that's where a probate proceeding could happen. Where this happens? When a person passes away with assets in their name alone. Happens all the time. That's why that court exists. That's why there are such delays, because of the caseload. It happens all the time. So what you're looking at is, if there is a last will and testament in place, that's called a probate proceeding. If there is no will, it's called an administration proceeding. Okay? And again, this can all be avoided. Probate is a validity proceeding. The judge needs to determine if that will is valid. Remember, I shared earlier that the law requires all of the children to sign off on this proceeding. Why? So that one has the opportunity to say, whoa, 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 that wasn't the will dad had. That was my older brother going in there on his deathbed and getting a new one signed, leaving everything to him. So it's to determine if the will is valid. And that court in that conflict happens every day of the week. And again, I keep repeating myself, but it can be avoided. You're looking at, depending on complexity, depending on a contest, you're looking at 6, 8, 10, 12 months. We just went through one that took 3 years. All right. We're not litigation attorneys, but we brought one in. But we were representing the nominated executor. It was actually a friend of the family who had passed away very prematurely. She was in her early 70s, massive stroke, wasn't expected at all. Wouldn't do a trust, as I said earlier. We can make our recommendations, and I really encouraged her to put her affairs in trust. Why? Because she was leaving everything to one child. And she was like, nope, I'll do the trust later. I just want the will now. Unfortunately, she was gone within 2 years. And that one son had to fight off his brothers for over 3 years before he could inherit anything. Didn't have to happen. If there was a trust in place, it would have saved that time, saved that conflict. So it's out there and it happens. Those that are a part of the probate proceeding, the children, they're not called heirs or next of kin. They're what are called distributees. And the process is, as I've said several times, the family has to sign off on it. And with this open court public proceeding, the creditors, if there are any creditors have the ability to file claims in the courthouse. No matter where you are, they can file claims against the estate there. And another little kicker I didn't type in there is that if you, as the executor of dad's will, pay out all the inheritance to the kids, but didn't realize that there was a creditor claim filed, or did know that there was a claim, a creditor, and you didn't pay it, that executor is now personally liable for that debt. And you got to pay for it out of pocket, or you got to go get the money back from your siblings. Good luck with that. So again, why put the family through the courts and the conflict? So what are the estate planning tools that can help us save time, save money, keep our affairs private, and keep us in control? I mentioned it a little bit earlier. It's what's called a power of attorney. I tell people this every day. It is the most important planning document, okay? This is what keeps the family out of the guardianship court, provided it's done right, okay? We'll go through my list here. Provided that it's durable, meaning that it is a document that will remain valid even if your parent or spouse becomes incapacitated. Must be a durable power of attorney. It must also be what we call a modified power of attorney. The standard form that New York State puts out there for New Yorkers to look at in the statute is not sufficient for aging, and it is not sufficient for asset protection or income protection. So what you're looking at is that power of attorney not only has to be in place, it's got to be the right one with the right modifications built into it. So if there's no power of attorney, or if the power of attorney doesn't have the right modifications, guardianship court. Okay, so crucial, very valuable document. It allows you to pick somebody for your legal, financial, and personal affairs. It doesn't cover healthcare. That's what's called a healthcare proxy. The person signing it is called the principal, and the person being appointed is the agent. And you can have more than one agent. Now, another very, very important and crucial, critical strategy that we use to protect families and keep them out of court and to minimize or eradicate conflict is a trust. And I know a lot of people go, oh, a trust. Of course you want to sell a trust. Listen, trusts are worth their weight in gold. The stress that they save, the money they save, the time that they save, hands down, most important document that we use when it comes to proper comprehensive estate planning, hands down. Okay, and trusts are not just for the wealthy. It's not, as I say, for the Rockefellers and the Kennedys, or now the Bezos and the Musks. It's for everyday people, truly, and they can help. If you have a house, if you have financial accounts, there is a trust that can help keep your loved ones out of court and out of conflict. But for our purposes today, there are primarily two trusts. The first two types of trusts. The first one is what's called a revocable trust, and the other one is called an irrevocable trust. And to fill in today and how we're addressing all these topics, there are 3 reasons that a person would implement a trust. All right. The first is to avoid probate, right? Stay out of that surrogates court, as I've been talking about. That would be needed if we have real estate in other property in other states. That would be needed if we're disinheriting, or we just want to keep things private. We want to save time and save money. Those are valid reasons. Another reason, though, somebody would use a trust is to protect their assets. Yes, there are tax trusts and creditor trusts, but primarily we're looking at what are we call Medicaid trusts, irrevocable trusts. Those are for everyday people that are concerned about long-term care. And what we do is we protect the house, we protect some of the financial accounts if appropriate. So asset protection is a very common reason. Another reason that people implement a trust is to protect the inheritance. Okay. I'm going to start, this is actually the first webinar in PowerPoint. I've actually included that as a reason, but for now on, I'm going to include that because we're seeing this more and more. And this would be, as I was getting into with the Smith family, if there's a potential divorce, if you have spendthrift issues, financial spending problems, if you have addiction issues, if you have a minor or a disabled, those are all inheritances that we want to protect. Okay. So what we're going to do here is when you have a revocable trust, that is built primarily to avoid probate. All right. Now, an irrevocable trust also avoids probate because the trust owns the asset and dictates where it goes next. So we don't need the court or the judge to get involved. But that revocable trust, when it comes to asset protection, it doesn't. A revocable trust is built purely for that probate avoidance. There's the person who sets it up, called the grantor, has all control and all access to what's inside a revocable trust. All right. So there's no protection, no asset protection with the revocable. However, the irrevocable is built just for that, to protect against taxation, creditors, nursing homes, Medicaid. The government is in some respects. So that's what the irrevocable is about. Now, this idea of inheritances going down to the children, grandchildren, gratefully, both of these trusts can protect against inheritance concerns and risks. The spendthrift issues, the divorce issues, the addiction issues, always included or should always be included in different types of trusts that we prepare. Okay, I hope that's making sense so far. And again, if not, I'll be around at the end. You can certainly ask your questions. Bottom line is, estate planning, I should call it comprehensive estate planning, is for every single adult, regardless of age, regardless of net worth, and regardless of how healthy you are. It's not just for people that are older or sick. It's not just for millionaires. We just ran a special here at the office for kids going back to college back in July, right? Everybody's going back to college these weeks, and you're seeing, unfortunately, there's a need for a power of attorney and a healthcare proxy. I've had 2 kids graduate college, and both of them power of attorney and healthcare proxy. Stuff happens. They're over 18. They're adults. So it's a necessary document, regardless of age, net worth, and health. Just to summarize a little bit, having a comprehensive plan will certainly allow the family to proceed and progress and handle your affairs with less time, no court costs, less legal fees, privacy. This one I stuck in 4 years ago during COVID, avoiding court shutdowns. That happened, and it could happen again. I mean, no estates were administered for 8-9 months. Having a plan, you don't have to locate the heirs. You can minimize any type of estate contests. You keep control within yourself and within the family. There's no executor liability to pay those creditors. You minimize estate recovery, which is a Medicaid risk if the assets are in your name when you pass away. And overall, to bring it all the way around full circle, having a comprehensive estate plan is going to bring less stress, cause less stress for the family, 100%. With that said, we still sit with families that desire what we call a probate plan. I'm not sure why, but perhaps it's one step at a time, and that's fine. We'll respect that. But a probate plan is going to consist of the last will and testament, which requires probate. It's going to be that durable modified power of attorney that I spoke about. the healthcare proxy for healthcare decision making, and ultimately the living will as well, which is going to be an end of life statement as to treatments you want, that you don't want. After that, when we have a client that's in a family that's conscious of the probate issues and delays and risks, we put in together a probate avoidance plan. It's going to be the same 4 foundational documents. You're going to have your will, your durable modified power of attorney, healthcare proxy, living will, but we add in the revocable trust. Okay, so this is done. We've had families, clients in their 30s put together revocable trusts. We've had families in their 90s put together revocable trusts, okay? It's about avoiding probate and keeping things private, saving time and saving money. Then ultimately we prepare an elder care protection plan for a significant amount of families. And with this, same 4 foundational documents, the will, that durable modified power of attorney, the healthcare proxy, the living will, but then we add in the irrevocable trust. All right. So these plans, the elder care protection plan in particular, is for folks in their 60s who are looking at the reality of mortality and aging and potential illness in the future, and that I might need care. I might need help more than my family can provide. So let's bring in an outside aid, or God forbid, a nursing home. The issue becomes, how do we pay for that? And oftentimes families rely on what's called community Medicaid or chronic care Medicaid for nursing homes. And again, we're not getting into that today, but our website, Tully Elder Law, has all of those webinars to talk about it a little bit more in depth. Or we provide free consultations. If you want to talk about the avoiding probate, you want to talk about asset protection, you want to talk about long-term care and how our nurse and social worker can help the family through the long-term care maze, it's a free consultation. Give us a call and we can talk about it. Every plan that we do for a family does not end when the documents are signed. We have for our planning clients what's called our client care program. And so for 1 full year, this is part of a comprehensive estate plan. So for 1 full year, calls, questions, changes to your documents, funding of your trusts, what goes in the trust, what doesn't go in the trust, an annual meeting so we can sit with you, the kids if there's questions, the accountant if there's issues. Our elder care coordinators conduct a personal care assessment by mail. They mail it out to you. That way we can see how you're doing and what's going on. It's, again, comprehensive planning, which is how we handle things here at Tully Law Group. I'm done. All right. So yeah, that was a lot of talking for today. I know I went fast because of the time limitations. But if there's any questions, I'm happy to answer them. Or you can, again, simply reach out by email directly to me, Brian, Brian, at Tully Elder Law, or call us at 424-2800, 631-424-2800. We now have offices in Melville, in Riverhead, and up in Northport Village. You can certainly follow us on Facebook and Instagram. I think we have some YouTube stuff, and I think they're doing TikTok, but I don't know. I don't have TikTok. A pleasure to talk to you all today. Let me see if we have any questions. Any questions, folks? Any questions? Any questions? All right, no questions yet. Anybody else? Be happy to answer them. All right, I'm not seeing anything pop up, so hopefully that was helpful. And again, follow up if you have any questions, and I'll be happy to answer them directly. All right, be well. Thank you.